Speaking of, hopefully everyone can see this, speaking of H-1B basics. So what is an H-1B visa? Well, an H-1B visa is what we call a professional worker or a specialty occupation visa. That means that if you are going to work as an H-1B worker, your job must require the minimum of a bachelor's degree or equivalent in a specific field, a specific area of expertise, and you must hold that required degree at the time that your employer is applying for your H-1B visa. And in addition to that, as I mentioned, there must be an employer-employee relationship. So there must be an employer-sponsored. An individual cannot apply for an H-1B visa on their own. They must have an employer and they must be considered an employee. So that means what we call W-2 employment, meaning that your employer would issue a W-2 form to the Internal Revenue Service for tax purposes to show that you are an employee, and the employer would be responsible for withholding your taxes and withholding Social Security and other tax requirements from your salary as part of you being an employee. So there's no 1099 employment between an H-1B employer and an employee. So 1099 meaning an independent contractor where there is no real employment relationship. It's more of a contractor to contractor relationship. That cannot occur with an H-1B employee. So an H-1B employee must be a W-2 employee. And of course, the H-1B employee must only work for the actual sponsoring H-1B employer. There's no outside employment besides working for that employer. However, you can have multiple H-1B employers provided that each employer applies for an H-1B for you. And then usually H-1Bs are granted in terms of in 3-year increments. There are some exceptions, which we'll talk about with respect to the H-1B entrepreneur rule, but in most cases you can get 3 years at a time on an H-1B with a maximum of 6 years total cumulatively on an H-1B, unless you have a green card application in process, which would allow you to extend beyond that 6-year limit. Some other basics to know is that employers have obligations under the H-1B. So employers are required, since they are the sponsors, they must pay a salary to the employee, and that salary has to be either the minimum of the actual wage or the prevailing wage. So there is a difference there between an actual wage and prevailing wage. So prevailing wage is pretty much what the government says through surveys that the salary or determines what the salary is typical for people in that specific occupation. So for example, if you are employed in Los Angeles County as an engineer, then there's a minimum, the prevailing wage determination by the government that says this is a specific minimum salary that must be paid to an engineer working in Los Angeles County. However, if your employer typically pays engineers more than the prevailing wage, then they must pay that actual wage, the wage that they normally pay. They can't say, oh, I normally pay $100,000, but since the prevailing wage is $80,000, I only pay $80,000 to the H-1B worker. No, they must pay the $100,000 if that is their standard salary for that particular occupation. They must also provide the same benefits as any other employees that they employ in the same position or similarly situated position. If someone is in a licensed occupation like physician, lawyer, sometimes teachers, architects, anything, CPAs, where there is a license required in order to perform that occupation, then before the H-1B can be approved, the employee must show that they actually hold that license. Another important fact to know that sometimes we're asked about is that you do not have to have full-time employment with an H-1B. You can have part-time employment. So as long as the H-1B application indicates part-time employment, you can be employed part-time and have actually multiple part-time H-1B employers, each of whom have submitted a part-time H-1B application for you.